Assalamualaikum warahmatullahi wabarakatuh. My name is AMANI NASUHA. In Malaysia, Muslims are governed in substantially personal law matters by Islamic law as set out in the various state Islamic law administration statutes. The High Court of Malaya and the High Court of Sabah and Sarawak do not have jurisdiction in respect of any matter within the jurisdiction of Sharia court. However, long before Article 121A1 was created by amendment, a historical and embracing problem that civil court faced in the Tanah Melayu was to be found in the well-established association in the case of Rahmah binti Ta'ad versus Latun binti Malim Sultan. The embarrassment is contained in the fact that judges of the civil courts lack and still do lack adequate knowledge of the Islamic law, thereby requiring in practice expert evidence to be led, whatever the personal skill of the individual judge. In the same case, however, further men by judge thought the existing court were competent to take evidence of Muslim law as well as matters of custom by virtue at least of section 57 of the evidence enactment. Little did those colonial judges know that 80 years later the jurisdictional debate would take such politically charged center stage in 21st century Malaysia. Despite even today, in the state of Malaysia, a federal law, the Muslim Courts Criminal Jurisdiction Act 1965, conferred jurisdiction upon courts constituted under any state law for the purposes of dealing with offence under Muslim law. Moreover, under item 1 of the state list, state legislature are given power to make law for the creation and punishment of offences by persons professing the religion of Islam against precept of that religion, except in regard to matters included in the federal list. The aim of amendment which created Article 121A, which provides that the two civil high courts shall have no jurisdiction in respect of any matters within the jurisdiction of the Sharia court, was in many ways to avoid for the future any conflict between the decision of the Sharia courts and the civil courts. Unfortunately, however, it appears to have caused even more confusion, uncertainty, and conflict than ever was the case.
Civil Court. According to Article 121 Clause A1, the courts referred to in Clause 1 shall have no jurisdiction in respect of any matter within the jurisdiction of the Sharia courts. The two high courts have civil and criminal jurisdiction, but no jurisdiction in respect of any subject under the jurisdiction of the Sharia courts. Clause 1A of Article 121, which was introduced to the Constitution by Act A704, which took effect on June 10, 1988, stipulates the exclusion of authority over Sharia problems. Numerous instances regarding the subject of conflict of jurisdiction of the civil and Sharia courts have gone up to both courts after the adjustment to some egregious amendment to Article 121. It can be seen in the case of Latifah binti Madzin against Rosmawati binti Sharibun, where a typical case involving such a conflict was called upon. In Latifah binti Madzin against Rosmawati binti Sharibun, Abdul Hamid J. stated that, to give one example, while Parliament may make law in relation to marriage and divorce, it is not permitted to make law on the same subject matter affecting Muslims, because it falls under paragraph 2 as Islamic personal law relating to marriage and divorce. The net effect is that marriage and divorce law of non-Muslims is a matter within the jurisdiction of Parliament to make, while marriage and divorce law of Muslims is a matter within the jurisdiction of the legislature of a state to make. It simply means that when a court's jurisdiction is challenged on constitutional grounds, it is still up to the civil courts to decide whether a matter is within or outside the jurisdiction of either court, which is the High Court or the Sharia courts.
Hi, my name is AIDA FASIHAH binti AHMAD TARMIZI and my metric number is 053936. Next, jurisdiction of Sharia court. It is established in all states through administration of Islamic law enactments and in the federal territories through federal law, except for the territories of Kuala Lumpur, Labuan, and Putrajaya. Syariah Court established by the Yang di-Pertuan Agong under Section 40 of Administration of Islamic Law Act 1993 and rules on the advice of the minister charged with the responsibility for the administration of religion of Islam. And it is a model that may be used nationwide. It covers the constitution, organization, and procedure, being in the state matters, and its jurisdiction is conferred by both state and federal law. The Federal Constitution of Malaysia gives the 13 states of Malaysia exclusive jurisdiction over the administration of Islamic law. In 1988, the Constitution was amended to clarify that the civil courts shall have no jurisdiction in respect of any matter within the jurisdiction of Sharia court. The Sharia courts established in each state have jurisdiction over personal status issues and some criminal offences involving Muslims, with separate laws applying to such matters. To determine whether Sharia court has jurisdiction, the state enactments can be referred to see whether there is an enactment that confers jurisdiction to the Sharia court on any given matter but excludes the matter in conversion out of Islam or apostasy. Although not conferred by state enactments, it still falls within the exclusive jurisdiction of the Sharia courts. The federal court has previously been asked to adjudicate cases involving conversion from Islam to Christianity, including in the 2007 landmark Lina Choi case. The federal court held that on the issue of her right to apostate and her current status, a Muslim or not, the matter falls under the jurisdiction of Sharia court. The federal court refused to order the National Registration Department to change the appellant's religion to Christianity and confirmed the decision in the 1999 case of Sun Singh against Breaking Kedah, that only Sharia courts have jurisdiction to hear cases in which a person renounced Islam, even if this is not explicit in relevant state laws. The federal court stated, as in the case of conversion to Islam, certain requirements must be complied with under Hukum Syara or Sharia laws for a conversion out of Islam to be valid, which only the Sharia courts are the experts and appropriate to adjudicate. In short, it does seem inevitable that since matters on conversion to Islam come under the jurisdiction of Sharia courts, by implication conversion out of Islam should also fall under the jurisdiction of the same courts.
Assalamualaikum warahmatullahi wabarakatuh. My name is NURIN binti Abdul Aziz. My matric number is 053079. I would like to present on the resolution over the conflict of jurisdiction between the civil court and the Sharia court. As stated from the previous slide, the conflict appeared in case which involving an individual status of religious, as those who convert had no idea how to resolve his property status and the court had not give a direct solution to such matter. Firstly, there should be an exposure to the society regarding to this matter. The public should know their right and their status after converted or reverted to Islam, even though the jurisdiction of the court over the matter had not been clearly seen. The jurisdiction do exist. Amendment over the Article 12, Clause 4 of the Federal Constitution as the article create dispute. Next, there should be a discussion over this matter in the Parliament as the resolution should be determined by those who represent the public. Petition should be made to support this resolution. Malaysia is a multiracial country. We should be considering this matter seriously as it revolves around the public. Those who had been confused with this matter will not be treated equally as their right had been invoked from the very beginning.
Moving on to the conclusion, first, if laws are made by Parliament and state legislature in strict compliance with the federal list and state list, there should not be any situation where there would be a clash of jurisdiction. However, where state legislature overreach and make laws within the domain of the federal parliament, such conflict cannot be avoided. Unfortunately, there are such state laws no more apparent than in the area of criminal law. Second, where there is any challenge to the jurisdiction of the High Court or to the Sharia Court, on constitutional grounds, the appropriate and only forum to resolve the issue is the apex civil court, which is the federal court. Accordingly, it is still for the civil courts to determine when a court's jurisdiction is challenged on the constitutional grounds. The question whether a matter is within or without the jurisdiction of either courts, which is the High Court or the Sharia courts. Third, it is clear that to speak of Article 121 Clause 1a, having taken away the jurisdiction of the civil courts in all matters pertaining to Islamic law is a fallacy. This article was not introduced for the purpose of outsing the jurisdiction of the civil courts. Fourth, the Sharia courts are inferior courts. They inhabit a sphere within the judicial space which is inferior to the superior civil courts, that is to say the Court, Court of Appeal, and the Federal Court. And lastly, the Sharia courts derive jurisdiction only by express provision and not by implication. It can never be that once the Sharia courts are established, the courts are seized with jurisdiction over all matters mentioned in Item 1 of the State List automatically.